Please be seated. All right, good morning. On the 11 o'clock docket, we're here on the Cineworld group case. It is 2290168. Electronic appearances have been made. If you wish to speak today, if you would please either press 5-star on your phone or approach the podium if you're Mr. Perez.
Good morning, Your Honor. Alfredo Perez on behalf of the committee.
Good morning. Ms. Foster, good morning. Wait a minute, did I not get you? Hold on, I didn't get you activated. Something happened. Let me try that again. Ms. Foster, now good morning to you.
Good morning, Your Honor. Personal Dallas, counsel to the matters.
Ms. Foster, tell me what we're trying to accomplish today.
Good morning, Your Honor. This morning we have a status conference on the NCM rejection motion. As Your Honor likely saw over the weekend, we filed a motion seeking authority to enter into a go-forward screen advertising agreement with NCM, as well as a joint venture termination settlement agreement. In addition to the motion, which seeks authority to approve those two agreements, we also filed a stipulation of dismissal, seeking to dismiss with prejudice the two adversary proceedings. So this morning, Your Honor, nothing to do with, in front of Your Honor, the status conference on the rejection motion will be addressed through the motion we are seeking authority to enter into the two agreements through. You'll see in the order for that motion, we seek authority to have the existing agreement rejected.
I'm sorry, you're breaking up a little bit, Ms. Foster.
Sorry, Your Honor, I'll say nothing to do this morning. We're going to handle rejection of the existing NCM agreement through the motion we're seeking to approve the two go-forward agreements.
And when are you asking me for a hearing on 1767?
On June 16th, I believe the date is at, I don't have the time in front of me.
Your Honor, I think that's already been set, but I believe I don't know if it's June 15 or June 16, but that has been set.
So on June 16th, the notice went out for a June 16th hearing, and I have it down at 10 o'clock. I just want to be sure that everybody is consistent on what we're doing there.
Yes, that's correct, Your Honor. 10 a.m. Central.
All time is central.
Fair enough, Your Honor.
I think there may be an error in it, and I don't think there's a disagreement between the parties, my guess is, but I want to, just so we don't get to the hearing with a potential error, or else let you clarify it for me. If you'll go to page 10, I think I'm gonna open it. There's a table, and it defines effective date on it. I'm trying to now get to it. Right. I was surprised that the effective date would be the earlier of those three events, because I would think you couldn't have an effective date until the later of the three events. I may be wrong about that, but I thought I better raise it today just to be sure we don't have an issue. But I don't know how. I mean, I guess you could make it retroactively affected back to the earlier of those, but you can't really make it effective, it seems to me, because little 1 is my approval, little 2 is a Jones approval, and little 3 I think is a confirmation order, probably. And so I think it's the later of the three, but if I'm wrong, let me know.
Your Honor, we'll take that back. Just looking quickly, I tend to agree, but we'll just confirm with NCM's counsel as well as our lender's counsel.
Okay. Mr. Perez, do you have any, that's the only real thing I had, is I want to be sure I have clarity when I get there, so.
Understood, Your Honor, and I believe the timing is, this is going to be heard on the 16th. I'm not sure when it's going to be heard in front of Judge Jones, but I think confirmation is in this case, is on the 28th. And I think there is a hearing in front of Judge Jones on the 26th. And those are all kind of conditions to this going effect.
Okay. Do I need to do anything to be sure Judge Jones gets it to a hearing, or maybe I should have NCM's counsel speak up maybe and tell me if I need to do anything to facilitate that?
Your Honor, I could add in here, counsel.
What is that?
Your Honor, I was just going to say, I know NCM's counsel has reached out to Judge Jones' chambers. I think we're just waiting to hear back.
Yeah, I can reach out better than they can reach out. And so, Mr. Harris or someone from that group, if you're available, would you please press 5-star? There we go. Yes, from 212 area code. Who do we have on the phone?
Yes, Your Honor. This is Adam Raven from Raven Watkins on behalf of NCM. My understanding is that Paul White, who's counsel for the debtor, has reached out to the debtor. NCM has reached out to Judge Jones' chambers. But we can certainly confirm that. If Your Honor thinks it would be helpful to also reach out to him, we certainly would appreciate that effort.
So, and I'm not looking for anybody to commit to this, but do you agree that I probably can't make mine effective until Judge Jones approves this, just in case he doesn't?
I think that sounds right to me, Your Honor. Having said that, I do believe that the hearing date with respect to the motion that was filed in the NCM case was also noticed to the 16th. I'm just not sure of the time, but we can certainly check with Paul White and confirm whether they've been successful in reaching out to Judge Jones and revert to the Kirkland team and then to Your Honor's favor.
Yeah, why don't we do this? If everything works out fine with y'all contacting Judge Jones, that's fine. I don't want to hold up my confirmation hearing because of any issue there. So if y'all don't get the hearing from Judge Jones, would you just place a phone call to Mr. Laws and he can contact Mr. Alonzo, or I can contact Judge Jones, and we'll get this I'm not going to control whether he approves it or not, but I think that he will in fact agree to hold a hearing so that the Cineworld confirmation hearing won't be delayed. So if there is an issue, just get in touch with Mr. Laws and he'll get in touch with me. Is there anything else that we can do today?
Your Honor, if I may, one other item.
Yes.
There are just a stipulation of dismissal that we filed in the two adversary proceedings. I think the parties, if Your Honor is able to take a look at those today, if the parties are eager to have those two entered.
So those get dismissed before the deal is approved?
Yes, Your Honor. So that was one of the terms that we agreed to with NCM, that the adversaries are dismissed with prejudice as the first step.
What if this doesn't get approved?
So the parties have lost their rights with respect to the claims that they've made through the adversary proceedings. NCM walks away, I can only speak to what Cineworld's adversary proceeding is in regards to, but the parties went into this negotiation knowing that both adversaries proceedings would be dismissed before the court had the chance to consider approval entry into the new agreements.
So I haven't looked at the adversary proceedings in a while. So if I've got this wrong, I've got this wrong. But in effect, at least one of the adversary proceedings seeks a declaration as to the meaning of the agreements. So if we don't approve the compromise, and by the way, I see no reason why this compromise isn't going to get approved. I don't want you misreading what I'm saying. But if we don't approve the compromise, we're going to have a dismissal with prejudice and no ability to resolve the dispute. I don't know, why does that make sense?
So, Your Honor, under the stipulation, it says the parties are, until July 10th, going to continue, waiting for entering both orders. Then on July 10th, if we don't have all the conditions precedent necessary to enter into the agreement with NCM, our no shop on Cineworld end, our no shop disappears, so we can engage with other parties. And all agreements that we've agreed to with NCM, termination agreement and go forward screen advertising agreement are terminated. The parties are left in a position where the agreements are terminated and Cineworld will have to continue seeking a new third party as a screen advertising counterparty.
Wait, if this is not approved, I've got to assume this is not approved for the purpose of today, even though I have no reason to think it's not going to be approved. If this isn't approved and the quasi-deck action, and again, I haven't looked at it lately, but that's my memory, the deck action that says what the go-forward rights are is dismissed with prejudice, how do we ever figure out what the go-forward rights are? Because this settlement is gone, people need to figure out what they're doing on a go-forward basis, and we have a dispute that is unresolvable because it's been dismissed with prejudice. This isn't making sense to me, so I'm missing something. Mr. Perez, go ahead.
So, Your Honor, the way that I read it was that, in essence, Cineworld, because of the fact that the agreement says you can go forward after July 10th, that in essence the...
What agreement says you can go forward?
The stipulation of dismissal that Ms. Foster just referenced, right? So in other words, we wait till July 10th,
okay.
And on July 10th, Cineworld is free to do all of the things that the otherwise adversary proceeding had prevented them from doing.
So it's not really a stipulation with, it's not just a dismissal, it's a dismissal with a substantive order built into it?
That's the effect of it, Your Honor. But obviously, I didn't negotiate it, but I think that's the effect of it.
What is the adversary proceeding number where that July 10th right would be preserved?
Sure, so it's filed with both adversary proceedings, so I'll give you the numbers. They're 22-03307.
Okay, I've got that one open, so let me take a look. So I don't see any language, and this may be part of the agreement. You're agreeing that you will not solicit anyone else until July 10th. What gives you the right to solicit after July 10th? Because we haven't rejected the agreement at this point, right? The NCM agreement is not rejected yet. So it would still be there and you couldn't violate it.
Yes, Your Honor. So the NCM parties agreed to allow us, despite anything that is said in their existing agreement, allow us to go ahead and seek to engage with another party. Further, all agreements terminate on July 10th to the extent we don't have entry orders.
So I want to go to, let's go to July 11th. On July 11th, the pre-petition agreement between Cineworld and NCM still exists on July 11th, right? Assuming if we don't approve the compromise, then on July 11th, those agreements still exist. If you then were to solicit in violation of the agreement, they are then going to sue you for violating the agreement, but we have dismissed with prejudice the ability to resolve that. I don't understand why in the world, I may not be understanding this, maybe we just need to redo it with some more clarity, but unless your agreement with NCM has disappeared on July 11th, then we're just going to be right back where we are, but we will have dismissed with prejudice the dispute. Ms. Ullin, go ahead, please. What am I missing?
I actually am not missing anything, Your Honor. I think you have found a plot hole in our situation. We agreed to dismiss both adversary proceedings with prejudice, and we agreed that the workshop is no longer in effect. We did not address the issue of what about the existing agreement that has not been effective, so not being rejected, and the enforceability and the efficacy of that agreement. You know, I think parties should take this back and revise it to make it clear on this point, because I think it is unclear.
Okay, look, I also believe the probability of this agreement not getting approved, of your compromise not getting, it's pretty low, right? I mean, y'all set forth a good faith reason for doing all this. It's a business judgment test. You've got all your major constituencies on board. I'm not sure it's going to be worth the brain damage to dismiss with prejudice the two adversary proceedings early. Having said that, if y'all want to figure out a different agreement, maybe it does, and I don't want to say I won't do that, because I'm not telling you that, but I don't see the benefit of doing it, and I think I'm about to put you guys through a bunch of hassle that is, with a high likelihood, completely unnecessary. But with that said, I'm going to ask that you file something in the proceedings asking me to delay consideration of the dismissals pending the parties reworking in it, just so we have a good record of it. Is that okay?
Your Honor, if I may, I believe Brian Lohan is trying to speak. Is that fair, Brian?
Mr. Lohan, are you already enabled? I don't think you are. Can you press 5* one time on the phone, or have you already done that? Found you. Mr. Lohan, sorry, I don't know what happened, but I wasn't seeing your hand raised, but I've got you activated now. Go ahead, please. I can't hear you, even though I've activated your line. Are you muted on your end? I have 312-583-2403 activated, if that's your number. But you may be muted on your own side. No?
Your Honor, if I may, Mr. Lohan trying to connect.
Sure, although we're not in a hurry, and if he's supposed to speak next, let's just let him dial back in.
So, My understanding of the spirit of the agreement was always that by July 10th, the parties would be able to go their separate ways without any further litigation or any further need to engage to allow, Cineworld to find a new party to use its spring advertising counterparty. So I hear Ms. Belinda on the potential misstep in the stipulation, but I think the spirit was always that the parties would be fully able to go their separate ways on the 10th. So I think that's part of the reason why the adversary proceedings were seeking to have those dismissed right at the top.
I understand that may be the intention. I don't think that's what the agreement says, because it leaves open, if the agreement is still out there, your client or the potential purchaser being subject to a lawsuit saying that NCM retains an exclusive right to provide the services and that any party is going to be liable to them. I don't want to get into merits, but I think it leaves that open. Mr. Lohan, go ahead, please.
Good morning, Your Honor. Can you hear me now?
I can hear you fine. I don't know what happened before. Thank you.
I'm not sure. I appreciate the accommodation. I do want to point out a couple things, and I think I missed a little bit of the back and forth trying to fix the audio problems, but it sounds like Ms. Foster, Ms. Hewlin, has kind of clarified to the court what we were trying to do and why the dismissal of prejudice was so important. I do want to point you to paragraph 4 of the proposed order. And I think we always figured that...
My paragraph 4 says each party shall bear its own attorney's fees, costs, and expenses.
I'm sorry, paragraph 4 of the proposed order to the motion itself, not the stipulation.
Okay, hold on.
I think that...
You're talking in the adversary proceeding?
No, in the motion to approve the screen advertising agreement. That's 1767, I believe, document number 1767.
Okay, hold on. I'm in paragraph 4. No, I'm not, I guess. The order to... Sorry, is this the order to 1767?
Yes, the order is 1767.
Sorry, I was in 1767. Yeah. So if we approve it, there's no problem. What if we don't approve this order?
If you don't approve this order, so if Your Honor doesn't approve this order, then we would have an issue. I agree with that. But if Your Honor, I think we always anticipated that the order would be entered first in the Cineworld case. It may take longer to be entered in the NCM bankruptcy case. And if you approve this order, then the Cineworld debtors would have the authority to reject. So to address the concern Your Honor raised a few minutes ago, yes, the Cineworld debtors would already have the authority to reject if the termination did occur.
No, so I want to back up the conversation for a minute. I thought Ms. Foster asked me to dismiss with prejudice the 2 adversary proceedings today.
Correct.
And if we dismiss them today...
Press 1 to listen to the recording. Press 2 to save the recording. Press 3 to re-record your message.
I think someone has dialed in a second number on their phone. Let's not worry about that. If I entered...
Message saved. Bye.
Somehow, Mr. Lohan, I'm going to blame you for this. I don't know.
I'll make it win.
All right. Well, let's assume that we dismiss with prejudice today. And I have to assume that we don't approve 1767, even though I don't think that's a likely event. Okay? So assume we deny 1767. I now get to July 11th. the agreements still remain in place. If Cineworld enters into a contract with Perez Inc. to provide advertising services, NCM would then have the right to bring a lawsuit against Perez Inc. alleging that it was violating NCM's exclusive right to provide advertising services within the theaters. In some sense, all of that is fine, except that we would have dismissed with prejudice a lawsuit that seeks to determine they don't have that exclusive right. That means this doesn't all gel, and I think Ms. Uland is agreeing it doesn't gel and that we need to fix it, because I don't think that was anybody's intent here. Nobody's trying to do that, but I think that's what it does, and that's where my worry is. What am I missing on that, Mr. Lohan?
If Ms. Uland is agreeing that we need to just modify the stipulation to cover that specific, I guess, suit or potential cause of action that NCM may have against a third party, then I agree we should button that up.
Well, it's against both you or third parties. That was just it. The agreements have to die, right, at some point under this stipulation, but the agreements don't die. They're still there under this dismissal. So I'll let y'all work through this. Yep, go ahead.
I think the flip side of this that we do not focus on is that on July 11th, Cineworld is going to be fully expecting that NCM is still continuing to provide advertising services under its non-rejected agreement. They don't want us to just walk away and turn off the ad. So we're going to have to be in this period of time where we're operating under a non-rejected agreement, and the parties need to have clarity about what that means.
I completely agree. I completely agree.
I'm going to take a step back and just explain kind of the bigger picture and why this is important to the confirmation effective date to rebuild, and then we can maybe figure out how to make the words better on paper. But I want your audience to understand kind of the reasoning behind how we try to see this.
Okay. I mean, I think I do understand the importance of it, and I think I do understand why it's such a good deal for everybody and why it should be approved. I just don't know why we can do the dismissal. So as long as you focus on that, whatever, but you don't need to persuade me this is a good deal. I start the hearing thinking it's a good deal. Somebody may come in and object and persuade me wrong, but the motion was persuasive motion.
And solely on the dismissal piece that I'll focus on. The legal estate is facing a choice. If we went with third party for screen advertising, we would have the litigation that was already pending in the adversary proceeding, and that you almost heard the summary judgment on a couple weeks ago, maybe a month ago at this point. If we went with NCM, it's possible that the agreement we would enter into could trigger litigation in NCM's bankruptcy. So we were faced with the choice of do we go with NCM or do we go with a third party? We ultimately went with NCM, but as a condition to going with NCM, given our financing committed, we have an outside date on the financing where it could terminate and could put in jeopardy the effective date. We said we're not going to have the legal estate bear the risk of any litigation the NCM estate may incur in connection with that agreement. Which is why the parties agreed up front that in order to de-risk the legal estate from any potential litigation in an NCM bankruptcy, we would dismiss with prejudice claims under the adversary proceeding and have those issues about the grow shop, the exclusivity, and the non-compete go away, and the intent was for those to go away for all time and eternity. Maybe we missed that in the verbiage, but that was the intent, and that's why it was so important to the legal side that having stipulations entered in advance of the substance abuse being considered.
First, I don't understand yet, if I were to sign these precise orders, how it resolves matters on July 11th if you were to do a transaction with a new third party. Just don't understand it. Maybe my fault, but I need to understand it. And second, I do understand why these dismissals with prejudice have to be entered on or before the date that we approve everything. They go hand in hand with what we approve. I haven't yet understood why we need to do them today. I don't mind doing them today, except that I think they're wrong. So I won't do them because I think they're wrong. But I have not yet heard the justification for doing these separately from approving the agreement. Again, I will do that, but not if it leaves this giant July 11th hole. And maybe you can explain to me away the July 11th hole. Or I think Ms. Ulan described it as a black hole. So
I don't know that I have a good answer to your specific question about NCM's claims against third parties. I think everybody's intent was the exclusivity, the no shop, and the non-compete. The issues that were being raised in the adversary proceeding would no longer be issues, period, full stop. And maybe the language got that wrong, and we'll look at it and try to make sure
and so long as you can do that and not affect what Ms. Uland is saying, which is, if we come to July 11th and this agreement hasn't been approved, who's going to provide the advertising services? So she's saying that you can't, that the easy solution that I thought, which was the agreements would terminate, doesn't work. It's going to be a more complicated question than that, but I'll let y'all work through it. But for now, Ms. Foster's request that I immediately dismiss the two adversary proceedings, I will take under advisement till y'all fix it. How's that?
Absolutely right.
Okay. Mr. Press, committee okay with, am I missing something from your point of view?
No, Your Honor, I don't believe so. I understood. I think that the intent was, as indicated by the parties, which is there's going to be a clean break, but,
right.
But there's the plumbing is maybe not correct.
Okay. So just, when y'all file an amended one, if you would let Mr. Laws know, I'll try and look at it pretty promptly. It is the case that parties have an absolute right under Rule 41 to jointly dismiss adversary proceedings, but when that joint dismissal includes substantive relief, it isn't an automatic right. So y'all can file something that says this is dismissed with prejudice, no conditions. I'll sign it because you have a statutory right to do that. That's not what you're trying to do. I don't have a problem with what you're trying to do. I'm trying to clarify why I have the right to say no, and I'm going to say no till I understand how it works. Unless y'all just do an absolute dismissal, which I think would be foolish, but statute gives you the right to be foolish. All right, we're going to go ahead and recess till 1:30 this afternoon. Thank y'all for dialing in.
Thanks, John.
Yeah.